Hey everyone, welcome back to Historical Quarrels. I am your host, Tyler Eckhardt. We are continuing where we left off from Double Jeopardy a couple weeks ago. Sorry about last week. Just got busy. But hope you guys are ready for the awesome, I guess, kind of finale to this episode that we're doing on Double Jeopardy and all the suits that have been done. It's going to be a good one. Let's get right into it now. You are listening to Historical Quarrels. So in 1971, we have the case of United States v. Jorn, which involved George Jorn, say that 5 times fast, who was charged with aiding and assisting in the preparation of fraudulent income tax returns. During the initial trial, the presiding judge, concerned that the government's witnesses might incriminate themselves without proper legal representation, declared a mistrial without consulting the defense or considering their objections. Jorn's defense attorney argued that a retrial would violate the double jeopardy clause of the Fifth Amendment, as the mistrial was declared without a manifest necessary and over the defendant's objections. The defense maintained that Jorn should not be subjected to the burden of a new trial due to the judge's unilateral decision to declare a mistrial. And the prosecution, represented by U.S. Attorney's Office, argued that the mistrial was necessary to protect the rights of the witnesses and to ensure a fair trial. They contended that the judge's decision was made in good faith and that the retrial was justified under the circumstances. And so, the Supreme Court, with Chief Justice Warren E. Burger presiding, reviewed the case. The evidence against Jorn included testimonies and documents indicating his involvement in preparing fraudulent tax returns. The key legal question was whether the mistrial declared by the judge constituted a manifest necessity that would justify a retrial without violating the double jeopardy clause. And in a 6-3 decision, the Supreme Court ruled in favor of Jorn, holding that that retrial after a mistrial declared over the defendant's objections can violate the double jeopardy clause unless there is a manifest necessity. Justice Harlan, writing for the majority, emphasized that the judge's decision to declare mistrial must be carefully scrutinized and justified by an urgent necessity. The court found that in Jorn's case, the mistrial was not justified by a manifest necessity, and thus a retrial would violate the double jeopardy protections, which I'm kind of like up in the air about, right? Because they were trying to protect some of the witnesses from essentially incriminating themselves. And so they were worried about that and needed a bit more time there. But at the same time, I feel like there is kind of a point. It's like, well, if if the prosecution fucked up and you guys are realizing, oh shit, these witnesses might, cause some issues, not just for themselves, but like also for us because of that, then I don't know. You should have done your homework before prosecuting, maybe. There's no detailed public record indicating that George Jorn went on to commit other crimes or was caught for something else after this case. So, and in 1976, we have the United States v. Dinitz, which involved William Dinitz, who's charged with conspiracy to distribute drugs. A drug dealer. How dare he? Distributing all those drugs. During his trial, Dinitz's defense attorney made an improper remark during the opening statement, leading the trial judge to expel the attorney from the courtroom. Faced with this situation, Dinitz requested a mistrial, which the judge granted, which, this would lead into the next defense attorney trying to say that it was double jeopardy at this point because because it was declared a mistrial. However, in a 7-2 decision, the Supreme Court would rule in favor of the prosecution, because the mistrial was requested by the defendant. And so it's like, you're the one who wanted to declare it a mistrial for you not having a judge. And then we granted you a judge for the next trial. Sorry, not a judge, an attorney. And they granted him an attorney for the next trial. So, and then we have United States in 1978 v. Wheeler, which involved Richard Wheeler, a member of the Navajo Nation who was prosecuted by the Navajo Tribal Court for disorderly conduct. After serving his sentence, Wheeler was then indicted by federal authorities for statutory rape based on the same incident, leading to a legal challenge over whether this constituted double jeopardy. Wheeler's defense attorney argued that prosecuting him in federal court after his conviction in the tribal court violated the double jeopardy clause of the Fifth Amendment. They maintained that since both prosecutions were for the same conduct, Wheeler should not be subjected to multiple punishments by different sovereigns. Which, I mean, yeah, but at the same time, this guy is a rapist, and so, well, a statutory, so he's a pedophile. And so I'm kind of like, I don't really care too much if he gets fucked over by multiple people. And then in a 6-3 decision, the Supreme Court ruled in favor of the prosecution, reaffirming the dual sovereignty doctrine, meaning that the tribal nations are separate sovereigns that predate the Constitution and thus possess inherent powers of self-government. So prosecutions by tribal and federal authorities for the same conduct do not constitute double jeopardy. The court emphasized that each sovereign has the right to enforce its laws independently. So essentially, like, even if you're on tribal ground, the federal government could still get you for the same crime, even if the tribal authorities also get you for that crime. So you could definitely serve double the sentencing there. So, and then in 1982, we have the case of Oregon v. Kennedy that addressed the issue of whether a retrial following a mistrial requested by the defendant is barred by the double jeopardy clause if the mistrial was provoked by prosecutorial misconduct. The defendant, Stephen Kennedy, was on trial for theft, and during the trial, the prosecutor made an improper remark implying that a key defense witness had a prior criminal record. And Kennedy's defense attorney immediately requested a mistrial, arguing that the prosecutor's comment was highly prejudicial and designed to provoke the mistrial. The trial judge granted the mistrial, and the prosecution sought to retry Kennedy, and then Kennedy's defense attorney argued that the retrial would violate the double jeopardy clause. So here you go, guys. Listen, you get into trouble for some theft. All you have to do is really piss off the prosecution and get them to fuck up and slip up, right? And so, because in a 9-0 decision, the Supreme Court ruled that retrial after a mistrial requested by the defendant is only barred if the mistrial is provoked by prosecutorial misconduct intended to provoke the mistrial. And so Justice Lewis Powell, writing for the majority, held that double jeopardy protections apply in such cases only when the prosecutorial misconduct was intended to goad the defendant into requesting a mistrial. And so the ruling established important precedent by clarifying the retrials are generally permissible when a mistrial is requested by the defense, except in cases where the mistrial was intentionally provoked, like it was here. So if you get them to intentionally provoke it, they're thinking they're going to do some big brain play, you can then get yourself into double jeopardy and get out of it. Okay, now we're finally here. 1997, we have the O.J. Simpson civil trial. So after acquittal in criminal trial, Simpson was found liable in a civil wrongful death lawsuit. This is the most famous one. So in 1997, O.J. Simpson faced a civil wrongful death lawsuit following his acquittal in the criminal trial for the murders of his ex-wife, Nicole Brown Simpson, and her friend, Ronald Goldman. Despite his acquittal in the criminal case in 1995, the families of Nicole Brown Simpson and Ronald Goldman sought justice through a civil lawsuit seeking damages for a wrongful death. The plaintiffs, represented by attorneys Daniel Petrocelli and Peter Gelbaum, presented compelling evidence during the civil trial. This included DNA analysis linking Simpson to the crime scene, blood samples, and testimonies regarding Simpson's behavior. The defense, led by attorney Robert Baker, argued that the evidence was unreliable, citing alleged mishandling and contamination. Judge Hiroshi Fujisaki presided over the trial, where the standard of proof was lower than in the criminal trial. And on February 5th, 1997, the jury found O.J. Simpson liable for the wrongful deaths of Nicole Brown and Ronald Goldman, awarding the plaintiffs $33.5 million in compensatory and punitive damages. And then following the civil trial, O.J. Simpson faced further legal issues in 2001. He was arrested in Miami for speeding through a manatee protection zone and for having an invalid driver's license. In 2007, Simpson was involved in a robbery at a Las Vegas hotel where he attempted to retrieve sports memorabilia he claimed belonged to him. This incident led to charges of armed robbery, and kidnapping. And then in 2008, Simpson was convicted and sentenced to 33 years in prison with eligibility for parole after 9 years. He was granted parole in 2017 and released later that year. So, I mean, he did serve prison time for, maybe not for killing, but for doing a bunch of other shit. His life kind of took a downward spiral for sure. And this essentially suing or trying to go after him for compensatory damages for the wrongful deaths was another way around the double jeopardy doctrine here that the family's legal team was able to do. And so the burden of proof, though, was lower. That should be noted. It was a little bit lower. And so that's another reason why. I don't know. There's a lot to say here. There's a lot to talk about with this case in particular, and I feel like it deserves its own episode. But I just wanted to briefly go over it and say this is another way around double jeopardy doctrine here. And in 2004, we have United States v. Lara. So this addressed the issue of whether the federal government could prosecute a defendant after a tribal court had already exercised its jurisdiction over the same conduct. This would be, again, another trial similar to earlier, but this time it was not for statutory rape charges, at least from what I found. He was initially charged in tribal court with assaulting a federal officer. So that's what he was in trouble for. And then in 7-2 decision, the Supreme Court ruled in favor of the prosecution still, reaffirming that yes, even if they get in trouble with the tribal court, the federal court could still prosecute them as well, making them essentially serve double sentencing there. Okay, and then in 2005, Michael Jackson would face civil lawsuits following his acquittal in a high-profile criminal trial for child molestation charges. In the criminal trial, Jackson was accused of molesting 13-year-old Gavin Arvizo at his Neverland Ranch. The trial, which took place in Santa Barbara County Superior Court, received extensive media coverage and ended with Jackson's acquittal on all charges on June 13th, 2005. The jury found that the prosecution had not proven the allegations beyond a reasonable doubt. Despite the acquittal, Jackson continued to face civil lawsuits related to similar accusations. These civil cases often have a lower standard of proof, known as the preponderance of the evidence, meaning it is more likely than not that the defendant committed the act. The lower standard makes it possible for plaintiffs to win civil cases even after a criminal acquittal. One notable civil settlement involved a case from 1993 where Jackson was accused of sexually abusing 13-year-old Jordan Chandler. Jackson settled the case out of court for a reported $15 million, although he maintained his innocence and claimed that the settlement was made to avoid a protracted legal battle and further damage to his reputation. In the aftermath of the 2005 criminal trial, Jackson faced additional civil suits. In such case, a former employee of Neverland Ranch sued Jackson, claiming wrongful termination and emotional distress. Jackson settled this lawsuit and others to avoid further legal complications and public scrutiny. He's probably sick and fucking tired of people going after him. But if he did molest those kids, I don't blame the parents for going after him. Jackson's defense team in the criminal trial included prominent attorneys Thomas Mesereau and Susan Yu, who argued Mesereau, and Susan Yu, who argued that the charges were part of an extortion attempt by the Arvizo family. They presented evidence and witnesses to challenge the credibility of the accusers and highlight the inconsistencies in their testimonies. Which, I mean, inconsistencies in testimonies, I need to look a little more into it, but sometimes it's like they're kids. They have a habit of misremembering things. And even then, it's like when you are traumatized at that young of an age, you're going to have a hard time because your brain does everything it can to protect. Will do everything it can to protect you from that. And it'll distort things. It'll turn people into like shadow monsters. There's a bunch of shit that can happen in a child's mind when they're traumatized. And so, of course, their testimonies are going to change. But again, I need to look a little more into it to determine that. Probably deserves its own episode, to be honest, doing like a deep dive into all of this. And then I can determine, okay, yeah, so Michael Jackson did it. Or it's up in the air, you know. But he would continue to face legal challenges and public scrutiny until his death in 2009. And so Michael Jackson would have a very complex legacy because of that. And then in 2011, we have Casey Anthony. Oh, this bitch. This fucking bitch. Casey Anthony faced several civil lawsuits following her high-profile acquittal in the criminal trial for the murder of her 2-year-old daughter, Kaylee Anthony. The criminal trial, which took place in Orlando, Florida, ended on July 5th, 2011, with Anthony being found not guilty of first-degree murder somehow, or aggravated child abuse and aggravated manslaughter of a child. She was, however, convicted on 4 counts of providing false information to law enforcement. Which, man, I'm still pissed about this. There's no fucking way she did not do it. Like, this is about as bad as O.J. Simpson, right? They're like, you 100% know O.J. Simpson fucking killed his wife. Same thing here, okay? One of the most notable civil suits was filed by Zenaida Gonzalez, who claimed that Casey Anthony had defamed her. During the investigation into Kaylee's disappearance, Anthony falsely told police that a babysitter named Zanny the Nanny, whose full name was Zenaida Fernandez Gonzalez, had kidnapped Kaylee. Gonzalez, who had no connection to the case, argued that these false statements damaged her reputation and led to significant personal and financial harm. The lawsuit sought damages for defamation, and the legal battle continued for several years. And in 2015, a judge ruled in favor of Anthony, stating that there was insufficient evidence that Anthony's statements were made with malicious intent to harm Gonzalez. Okay, sure. Maybe she didn't purposely do it to fuck her over. But what she did fuck her over. And so I don't know how she won this legal battle. I swear to God, she has to have some like insider connection to judges here to be getting off the way she has been. It's ridiculous. Absolutely ridiculous. Okay. And then there was a civil suit for investigation costs. The Texas EcuSearch, a nonprofit search and recovery organization, sued Anthony to recover the costs they incurred while searching for Kaylee, based on the premise that Anthony knew her daughter was already dead. The organization argued that Anthony's false information led them on a futile search, causing them to expend significant resources. The case was settled out of court in 2013 for an undisclosed amount. So, you know, she paid them. Okay, and then Roy Kronk, the meter reader who discovered Kaylee's remains, also filed a lawsuit against Anthony, claiming that her defense team's accusations against him during the trial had defamed him. Anthony's defense team had insinuated that Kronk might have been involved in placing Kaylee's remains to collect the reward money, and the lawsuit was also resolved out of court. Oh, man, I hate this bitch. I fucking hate this bitch. The fact that, like, she has not suffered enough, in my opinion, for what she did to her daughter, or even then, the blatant negligence that she had that caused her daughter's death, if she didn't do it, still, oh my God, I do not know how. I get being a parent is hard. It is difficult, okay? Being a single mom is difficult. But man, that bitch. There are no words to describe my fucking hatred for her. I hope to God some evidence eventually comes out like that is just completely damning to the point where even after her acquittal, something like they're allowed to like fucking go back and be like, no, this shit needs to get reopened. I don't know. I don't know, man. There should be some exceptions made for the double jeopardy law. And she is one of them. Oh, I hate her. Hate her so much. Oh, okay. Moving on. I will do a full episode on this on that bitch later. Like I'm not kidding. I'm going to do a full Casey Anthony deep dive going into it. Just talk about just like how there's no way she didn't fucking kill her daughter. There's absolutely 0% chance. But that's for another time. Okay. Then in 2012, we have Bluford v. Arkansas. So the case of Bluford v. Arkansas dealt with the issue of whether a retrial on lesser charges is permissible when a jury hangs on those charges but acquits the defendant on more serious charges, provided the acquittal was not formalized. The defendant, Alex Bluford, was charged with capital murder, first-degree murder, manslaughter, and negligent homicide in connection with the death of his girlfriend's 1-year-old son. During Bluford's trial, the jury reported to the judge that it was unanimous against guilt on the charges of capital and first-degree murder, but deadlocked on the lesser charges of manslaughter and negligent homicide. The judge declared that a mistrial without formally recording the jury's unanimous decision on the more serious charges. The prosecution sought to retry Bluford on all charges, including the more serious ones. Bluford's defense attorney argued that retrying him on the charges of capital and first-degree murder would violate the double jeopardy clause of the Fifth Amendment. And then the prosecution, represented by Arkansas Attorney General Dustin McDaniel, argued that since the jury did not formally acquit Bluford on the more serious charges and a mistrial was declared, the state should be allowed to retry him on all charges. They maintained that the double jeopardy protections did not apply because there was no formal verdict of acquittal. This is some 4D chess going on here, right? And in a 6-3 decision, the Supreme Court would rule in favor of the prosecution, holding that retrial on lesser charges is permissible if the jury hangs on those charges but acquits on more serious ones, provided the acquittal was not formalized. And because it wasn't formalized, they're able to retry. And go on and find him guilty. And then in 2013, Evans v. Michigan, and this was addressed the issue of whether a mistaken acquittal due to the trial judge's error bars retrial under the double jeopardy clause of the Fifth Amendment. The defendant, Lamar Evans, was charged with arson for allegedly burning down a vacant house in Detroit, Michigan. During the trial, the judge erroneously required the prosecution to prove that the burned building was not a dwelling, a fact that was not an element of the charged offense under Michigan law. Based on this incorrect requirement, the judge directed a verdict of acquittal after the prosecution failed to provide evidence of the non-dwelling status of the building. The state appealed, arguing the judge's error did not preclude a retrial because the acquittal was based on a legal mistake. Evans' defense attorney argued that retrying them would violate double jeopardy, of course. And in an 8-1 decision, the Supreme Court ruled in favor of Evans, holding that a mistaken acquittal due to a trial judge's error bars retrial under the double jeopardy clause. So if a judge fucks up, you're good, guys. That's the way to get away with burning down a house. Way to be. And then in 2016, we have Bravo Fernandez v. United States. Now, this one was to see if double jeopardy clause allows for a retrial when a jury returns irreconcilably inconsistent verdicts and the convictions are overturned on appeal. So the defendants, Juan Bravo Fernandez and Hector Martinez Maldonado, were convicted in federal court of bribery, conspiracy, and traveling in interstate commerce to carry out the bribery. However, the jury acquitted them of violating the Travel Act, an acquittal that seemed inconsistent with their other convictions. Bravo Fernandez and Martinez Maldonado's convictions were later overturned on appeal due to improper jury instructions. The key issue was whether the government could retry them on the overturned charges, given that the jury's acquittal on one account appeared inconsistent with its guilty verdicts on the related counts. And so, In a unanimous decision, the Supreme Court would rule in favor of the prosecution, allowing for the retrial. And Justice Ruth Bader Ginsburg, writing for the court, held that the double jeopardy clause does not preclude retrial when a jury returns irreconcilably inconsistent verdicts. So if the jury is just fucking stupid, then they can retry you, okay? And the convictions are later overturned on appeal. So this ruling clarified the double jeopardy clause permits retrial in cases where procedural errors invalidate prior convictions, even if the jury's initial verdicts were inconsistent. Yeah, good to know. It's definitely good to know. If your jury is fucking stupid, you can get retried, and they'll find a new jury essentially, which I think is kind of, I know that can get a little iffy there, but it is under very specific circumstances at the very least. Okay, then we have Puerto Rico v. Sanchez Valle. Okay, this addressed whether Puerto Rico and the federal government are separate sovereigns for the purposes of the double jeopardy clause, which they would go on to find that Puerto Rico and the federal government are not separate sovereigns for the purposes of double jeopardy. Justice Elena Kagan, writing for the majority, emphasized that the authority to prosecute in Puerto Rico ultimately derives from the federal government. The court held that because Puerto Rico's power to enforce its laws originates from Congress, it does not constitute a separate sovereign entity from the federal government under the dual sovereignty doctrine. So that's another way to ensure you don't get double charged. Is you commit all your crimes in Puerto Rico, get tried there, stack the jury, get them to acquit you, and bam, you're golden. Go Puerto Rico. That's fucking crazy that rule works there, but it doesn't work in some of the other areas of the U.S. But, you know. And then we have in 2019 the case of Gamble v. United States. This addressed whether the double jeopardy clause of the Fifth Amendment prohibits subsequent state to federal prosecutions for the same conduct under the dual sovereignty doctrine. And as you all, I'm certain, are aware by now, the Supreme Court reaffirmed the dual sovereignty doctrine here. So anytime it is the state and federal government going after you, you will get tried twice. And you will fucking burn for it, basically. And then tribal and federal authorities, again, dual sovereignty doctrine. And because the tribal council has their own separate sovereignty and their own way of dishing out the punishments, they could punish the same individual twice for the same crime here. In 2022 and then 2023, we have Smith v. United States. James Smith had been convicted of a serious federal offense, but the conviction was overturned on appeal due to procedural errors during the trial, including improper jury instructions and exclusion of exculpatory evidence. The Supreme Court would rule in favor of the prosecution, holding that double jeopardy does not bar retrial when the conviction is reversed due to procedural errors. So, that's good here. And then last but not least, in 2024, we have McElrath v. Georgia. It was a recent case that further clarified double jeopardy protections after acquittal. Okay. The defendant, Jason McElrath, was acquitted of serious criminal charges related to armed robbery and assault in a Georgia state court. However, after his acquittal, the state sought to prosecute him for a related but distinct offense arising from the same incident, arguing the new evidence had emerged. So, the prosecution, represented by Georgia Attorney General's office, argued that the new charges were based on different elements and the facts that had not been considered in the original trial. They maintained that the double jeopardy clause did not apply because of these. The new charges constituted a separate offense, and the emergence of new evidence justified the subsequent prosecution. And in a 6-3 decision, the Supreme Court ruled in favor of McElrath, holding that double jeopardy protections barred the subsequent prosecution. Justice Elena Kagan, writing for the majority, emphasized that once a defendant is acquitted, the state cannot circumvent the double jeopardy clause by bringing new charges that are essentially based on the same conduct. So, good. I guess good for him. He got away with that. Or maybe, he shouldn't have been tried in the first place. But that brings us to the end of today's episode. Hey everyone, welcome back. Thank you for listening to the last little bit of what I had written. I ended up skipping over a few prominent cases because it started to feel like it's just like a repeat of things. And to be very honest with you guys, I have been dog shit tired. I got sick last week, and it caused a bunch of issues. But I do have an update about this. On January, so there's some. Sorry, my mind is just all over the place today. But update for double Jeopardy here. The plea deals with the January 6th convicts. Some of the people charged were vacated by the Supreme Court ruling, but there is some Department of Justice skullduggery. And again, this is from Mike Ritz, listener. He updated me here, so I'm just going to read what he told me verbatim. I already loaded into the text. And he wanted me to check in to see if that was normal, which, based off of everything that I was talking about here, yes, Mike, it is absolutely normal. There are lots of protections in place for double jeopardy clause, and lots of ways. Like after you essentially served out your sentence, and if you are vacated from the prison or like let go based off of like a nonviolent offense, you are considered to have served your sentence, and they cannot retry you again after you've served out your sentence because you've already been convicted and charged, and essentially you dealt with your prison sentence. So they cannot be retried again. So Mike, yes, that is normal. That happens quite a bit, and especially with the recent, prisons getting vacated quite a bit. But yeah, that's kind of it there. Next week we're gonna be getting back into a normal swing of things. Hour and a half, 2 hour long episodes. Doing that again. Again, sorry for the lackluster couple of weeks here. Just trying to get back in the swing of things. I've also been off my meds for a little bit, and oh man, I feel like I'm super weird when I'm not on my medicine. Hard Homies will be coming back as well, I hope next week. So look forward to that. More D&D shenanigans. If you've been listening to that and enjoying that. Other than that, guys, I don't know. If you like the episode, leave a review, share it with a friend, get some more people listening to this. We always want to grow the fam here, and keep on doing what you've been doing. I love you all, and I'll see you next Monday with some new quarrels. Bye-bye.